Hello, everyone, and welcome to the Sandra Day O'Connor Institute's Constitution Series, Equality and Justice for All. I'm Trish Rifo, president of the American Bar Association from here in Phoenix, Arizona, and we are delighted to have all of you here with us today. We are particularly honored today to have with us Judge Douglas Ginsburg of the United States Court of Appeals for the DC Circuit. For 25 years, Judge Ginsburg has heard more than 100 cases annually as one of the top appellate judges in our country. Judge Ginsburg was appointed to the DC Circuit in 1986 by President Ronald Reagan and served as the chief judge from 2001 to 2008. After receiving his BS from Cornell University and his Juris Doctor from the University of Chicago Law School, he clerked for Justice Thurgood Marshall on the United States Supreme Court. Thereafter, Judge Ginsburg was a professor at the Harvard Law School and an assistant United States attorney in charge of the Antitrust Division at the United States Department of Justice. Concurrent with his service on the federal bench, Judge Ginsburg has taught at the University of Chicago Law School and the New York University School of Law. Judge Ginsburg is currently a professor of law at the Antonin Scalia Law School, George Mason University, and a visiting professor at the University College London Faculty of Laws. A documentary series on the Constitution hosted by Judge Ginsburg aired nationwide on public television entitled Freedom, If You Can Keep It, that explored the struggle of our forefathers to create freedom, the struggle to expand freedom to every American, and the struggle we are experiencing now as a nation to preserve it. As we begin our program, we invite you to send in your questions during our question and answer following Judge Ginsburg's presentation via YouTube live chat or a Facebook comment. So now please join me in welcoming Judge Douglas Ginsburg. And there he is, the wonders of technology. Welcome, Judge Ginsburg.
Thank you. Thank you.
Before we speak about the topic that brings you with us today, I wanted to take a moment to first, I guess, acknowledge that you are not related to Ruth Bader Ginsburg, the justice whom we lost last Friday, but obviously worked with her and knew her well. Would you care to share with us some thoughts and remembrances about Justice Ginsburg?
Sure. Well, I went on the court in 1986, and Ruth had been there for 6 or 7 years at that point. And she left in 1993 to go on and do other things, as you know. So we were colleagues for 7 years. We sat together on many cases. And her loss now is very much like a loss at my court as well, because she was such a prominent and fondly remembered alumna of our court. Sitting with Ruth was always, I won't say intimidating, but everyone had to be on their mettle because she was going to be super prepared. There was many a time when we would hear argument in a case and then retire to conference in order to discuss it. And after we've discussed it, she would produce an order that she had written before we ever heard the arguments, because she was pretty confident of how it would come out and what she thought the order should say. So I've had 30 colleagues over the years. I don't think anyone else has done that. So Ruth's well remembered for being a bit ahead of the curve at all times.
Well, indeed, and she was always a wonderful friend to the American Bar Association, so we particularly remember and honor her this week. So you are here today to talk about a very interesting project, and I wonder if you could begin by telling us where it started, how you became involved in this work.
About 4 years ago, I was asked by Free to Choose Network, which has been doing public television for about 40 years, if I was interested in hosting a program on the Constitution, which I was. And I was because of the, I think, rather sorry state of civics education in the United States these last couple of decades. Millions of students are graduated from high school every year without having had a course in civics, without knowing anything really about the Constitution, our system of government, and in many cases, even our history, because history has been compromised as well and eliminated or made optional in many high schools. And so this was an opportunity to do something through the medium of public television that could also be used to reach students. And Free to Choose Network has an educational affiliate called izzit.org, which just does materials for teachers. So they've taken these 3 hours and turned them into a large number of lesson plans, a significant segment for Black History Month, teaching materials, written materials that go along with the program, and sent the program and any materials that teachers requested to 170,000 teachers who have signed up, teachers of history or civics, to receive materials that they would find useful. So it's been possible to reach, is possible to reach about 1 million students a year, each year, for as long as the issues that we address remain relevant. And I'm sorry to say, I think that will be a long time. So
that's an extraordinary breadth of folks to reach. And obviously, Justice O'Connor has long had a deep passion around civics education. So it's especially appropriate to have you here with the Institute to talk about this in light of her interest.
I've often said the reaction that is set in to restore civics to an important place in the curriculum, really, the credit for that really goes to Sandra Day O'Connor for having started that effort, or at least given it a very high profile at an early stage. Now there are other organizations that are helping. And in the last year, 4 states, 2 by gubernatorial decree and 2 by legislation, have reinstituted or instituted a requirement that to be graduated from high school, public schools, the students must have passed a course in civics. So that things are starting to turn around perhaps, but if so, there's a long way to go. And working with the Sandra Day O'Connor Institute is a real pleasure for me to help make that happen.
Well, anything we can do to make any of our citizens, but particularly our youth, more literate as citizens is an important step forward, isn't it?
Just remember, these people vote. I really want them to know what they're doing. Whatever their choices may be, they should be informed.
Indeed, indeed. Well, we look forward to your presentation, and I'll jump in from time to time with some questions as we go, if I may. Sure,
thank you. So as you'll see when the titles come up, the program has been renamed actually before it was issued as A More or Less Perfect Union, because what we're doing in part is recounting how the protection of the Constitution was extended to ever more people over the years, going from a relatively small group of voters, that is to say, men who owned property, to where we are now, where the entire population that had once been enslaved is enfranchised. Women have the vote. Now 18-year-olds have the vote. So it's been a story in which protection for our liberties has been extended in terms of the people covered by the Constitution, protected by the Constitution, and yet somewhat compromised by things that the Congress and this has done and the Supreme Court has tolerated over the years. So one of the themes in the show is that there is a debate that's been going on for probably 30 or 40 years in the legal academy and in the courts over how best to interpret the Constitution. And the starting point for that discussion is the point that we have a written Constitution. The only long-lived Constitution before that was that of Massachusetts in 1780. Ours of 1787 has been a model for many constitutions around the world, often less well observed in other countries than here. But the important point to think about as a starting point is that it is a written Constitution. Can I have the next slide, please? This is a decision that was issued by Chief Justice Marshall in 1803, probably the most important decision that the court ever issued. And read it carefully, I'll help you with that. The powers of the legislature, as the Congress, are defined and limited, and that those limits may not be mistaken or forgotten, the Constitution is written. To what purpose are powers limited, and to what purpose is that limitation committed to writing, if these limits may at any time be passed by those intended to be restrained? The distinction between a government with limited and unlimited powers is abolished if those limits do not confine the persons on whom they are imposed, and if the acts prohibited and acts allowed are of equal obligation. Now, what the Chief Justice was addressing here is not only that it's a written Constitution, which he says expressly, but the understanding that many people don't have, frankly, that the Constitution governs those who govern us. There's very little in it that applies to you or me. It's all about what the government is authorized to do and what it's prohibited from doing. Or as one of the members in the show says, what the government can do for us and what the government can do to us. So if we could have the next slide, please. Chief Justice Marshall's view was the reigning view, and it was observed carefully by the courts. Here's a 1905 decision. It's 102 years later, reiterating the same point. The Constitution is a written instrument. As such, its meaning does not alter. That which it meant when adopted, it means now. Now, over the 20th century, after that decision was issued, our Supreme Court became less and less cognizant of the strict adherence to the terms of our written Constitution. And it tolerated more divergence in upholding laws passed by the Congress that were only tangentially tethered to anything in the actual Constitution. Have the next slide, please.
The written Constitution is all that matters. We, the people, is how it starts.
I'm afraid too many people worship the Constitution. We are being ruled by people who have been dead for 200 years.
How should the living interpret the words of the dead? The debate comes down to the document's original meaning versus a living Constitution.
Originalism is simply the proposition that the meaning of the text of the Constitution must remain the same until it's properly changed.
It's actually very hard to discover often what the original meaning was, because the text of the Constitution often doesn't give you that much guidance.
And I think we delude ourselves if we believe that there is some objective meaning or correct answer.
I don't believe that. If that's true, I can't see the point of having a written Constitution in the first place.
I'm one of the living guys. I believe that the Constitution is ever evolving.
There are going to be circumstances where we have to interpret the meaning of a word. I happen to be fairly limited in how far I'm willing to go.
But originalism does not say, and stick with that through eternity. Article 5 of the Constitution specifically contemplated that the Constitution could and should be amended.
The problem is the Article 5 amendment process is extremely difficult. It's very, very hard. I think the best way to think about a written Constitution is it's a starting point, but it's not the ending point.
Of course, we do our best to understand what the text meant at the time. But for all of the debatable issues, that's a starting point.
If you're a living constitutionalist, it could be whatever you want it to mean. In fact, the only living constitution is a constitution that's followed.
That has almost nothing to do with modern judicial review, because in all modern cases of any importance, the Constitution is not clear.
We're not writing on a blank slate, but we are filling in the blanks and figuring out what the Constitution should be.
The Constitution does evolve, but it evolves slowly, it evolves with the time, it needs to be tweaked.
All of us agree that the Constitution should be updated. What we disagree on is who is to do the updating.
That's what the political process is for, to resolve those difficult questions.
The last people you want to be changing that document are judges.
The judiciary is not licensed by the Constitution to add to or subtract from the text of the Constitution.
What the Supreme Court says it means is not actually the Constitution. The Constitution is the Constitution.
The idea that the Constitution should evolve is really inconsistent with it being the law of the land, the supreme law of the land. The alternative is a law that's forever uncertain, no more stable, no more reliable than popular opinion of the time. Opinions change, mores change, the words don't.
So, Trish, you see we've got this debate in these 3 minutes out of the 3 hours in the programs over original meaning, what the framers understood the words to mean, and most important, perhaps, what those people who ratified, accepted the Constitution understood the words to mean, versus the idea that, well, that's not really key. The Constitution needs to be updated by judges. So 5 justices of the Supreme Court would be authorized to revise the Constitution. And that is I mean, I made myself clear as to where I stand in that debate, but it is a lively debate. And throughout the program, we have to pay attention to it because it's had an enormous influence on our Supreme Court and on the limitations on our government.
Well, and it's aggravated, isn't it, Judge Ginsburg, by the fact that we keep bringing to our court system, and in particular to the Supreme Court, some of the most contested, divisive, challenging, hard issues that we face, and saying, y'all figure it out and tell us what the answer is. Don't you think that makes it even more difficult?
Well, yes, and that happens for 2 reasons. One is that the Congress often writes statutes that are quite ambiguous and quite remote from any power given them in Article 1 of the Constitution. And the court has found ways to accommodate those laws. But more to your point, people have been bringing claims to the Supreme Court to which the court might well have answered, well, there's nothing in the Constitution that covers that. Therefore, it's left to the states. And that's what the court did until at least the 1970s. When it started finding ways or making up ways to express itself on subject matter that had never come up before because it wasn't in the Constitution. But I have here a more prosaic example, no longer such a controversial one. The Commerce Clause. The Congress shall have the power to regulate commerce among the several states. Now, everyone understands that commerce means trade. It meant that then, it pretty much means that now. We have trade in services today that we didn't have because communication didn't allow it in the 18th century. But the Congress has the power to regulate trade among the several states. So things that move from one state to another. That does not include, and the court said many a time, It does not include labor relations or manufacturing, mining. Those are local activities. And that was where things stood until the late 1930s, when the Congress started to regulate things that were not commerce among the several states. Here's what happened. If we could see the next video.
Ernest Hemingway slept here. Now they do, descendants of Hemingway's six-toed cats. The Hemingway home is dedicated to preserving the legacy of author Ernest Hemingway and of his cats. In Key West, anything goes. Chickens need no reason to cross the road, or a license for that matter. But when the Federal Department of Agriculture got wind of the museum's cats, it dictated how they should be cared for.
The museum challenged it on Commerce Clause grounds and said these cats are marooned at the very southern tip of Florida, will never cross a state line, and furthermore, they were not bought or sold, they were merely born.
To the framers, commerce meant I send something to you in Boston when I'm in New York. That was interstate commerce of the kind that could be regulated. When two people in the same state traded something, that was not interstate commerce and therefore could not be federally regulated. That was the intention of the framers.
The framers didn't design an almighty federal government that could reach down right into your backyard or barnyard.
During World War II, there was a farmer who grew grain, and he fed that grain to his own animals.
And the federal government had a program at the time that dictated how much wheat farmers could grow on their own land. And he said, hey, that's not constitutional. Why? Because I'm not engaged in interstate commerce.
But in Wickard versus Filburn, the highest court in the land thought otherwise.
And in a convoluted analysis, the Supreme Court declared that because that wheat would not be used in interstate commerce, it still impacted interstate commerce through some type of displacement.
So they're taking the Commerce Clause and stretching it like a rubber band to apply to any kind of business when it was originally meant just to be for cross-border commerce, like it says.
I agree, but some scholars disagree. In their view, there's little, if anything, beyond the regulatory authority of the federal government.
In an economy like ours, things really are interconnected. And what goes on one farmer's farm really does affect what happens elsewhere. And so when the Supreme Court says the Interstate Commerce Clause gives Congress the power to regulate things that seem awfully local, it's not just engaging in some kind of trap to expand federal power. It's recognizing an economic reality.
If the test under the Commerce Clause becomes, does it affect commerce, then everything affects commerce, whether you do something or don't do something.
Well, once you have the power over anything that affects commerce amongst the states, then you basically have the power over everything.
Everything? Even Hemingway's cats?
The 11th Circuit Court of Appeals, and I kid you not, said that because the museum features these cats on its website and has cat-related merchandise in its gift shop, that is a substantial connection to interstate commerce, and that opens the door for the federal government to come in and exert control. Not making that up.
Well, as you can see, that is not interstate commerce as it was originally understood. Nobody would pretend otherwise. But the court had said, to say in that case, Wickard against Filburn, if it substantially affects commerce. Now, do the cats have a substantial effect on commerce? I think if we could see the revised version, the next slide, please, of the Commerce Clause, here's what we have today. So this is the case, right? Even if the appellee's activity be local, not regarded as commerce, may still be reached by Congress if it exerts a substantial economic effect on interstate commerce, irrespective of whether that effect might, at an earlier time, have been defined as direct or indirect. So nothing is too local, well, almost nothing is too local, too non-commercial, too indirect, to be within the reach of the congressional authority to regulate interstate commerce.
But Judge, can I just ask, how much of that is a function, as was suggested by some of the folks who were interviewed, of the change in economic conditions? since 1787.
Oh.
From the internet to everything else, isn't it true that things are vastly more interstate connected today than they were in 1787? And doesn't that matter?
Well, it would matter if it were put as an amendment to the Constitution and people were asked to approve it. We have a democratic process for amending the Constitution. It is not no one would maintain it's the exclusive province of the Supreme Court. I think it's not their province at all to amend the Constitution. Now, obviously, they have to interpret the Constitution. But there is some point at which interpretation becomes revision because it's simply not really grounded in the words.
And that's the fight, isn't it? It's where is that line?
Right. And I'm taking a few examples here where, in my view, it's way over the line, not really a matter of interpretation. This has happened. This is 1942, and this is not reversible. I mean, even no one would say the Supreme Court now has to reverse that decision and let the Congress propose an amendment, because the whole country has grown up in reliance on this. So it's irreversible, but that doesn't make it legitimate in its origins. So if you just take the next slide, and by the way, the substantial effect on commerce you see here in the terms, it actually is a discernible effect, because the cats don't have a substantial effect on commerce. They have either an imaginary or a barely discernible effect. So that's where we are. Courts are put in the position of saying things they can't really believe because the Supreme Court precedent requires it. And we do adhere to the Supreme Court precedent, you can be assured. So that's a fairly blatant example. Let's take a look at another one. We have the next slide, please. This is the takings clause of the Fifth Amendment. Nor shall private property be taken for public use without just compensation. Private property is not a hotly disputed term. It does have to be interpreted sometimes, but it's not controversial. Just compensation is clearly the market value of whatever was taken away. And people can bring cases and argue over whether they got the market value, but that is the standard for just compensation. The public use standard, well, you might think that's pretty cut and dried too, because from the very founding of the Republic until a dozen years ago, public use was understood primarily to be a school, a highway, a post office, things for public use. Let's see what happened though after that. Grab the next video, please.
As a kid growing up with pianos, I remember the first time I ever broke a string, my dad said, "You broke it, Charlie, you're gonna fix it." The first musical director of one of the casinos, he came to me and said, "Charlie, I have a lot of pianos here." So that's what started my career in piano tuning in Atlantic City.
At the beginning of the 20th century, Atlantic City was America's playground. But after World War II, its fortunes declined. The city then gambled on casinos and lost big. Much of America's playground is now a casino wasteland.
This building is not just walls. This building is a cross-section of my life. It's like a living, breathing thing. We were blessed to be able to come as immigrants to this country after what my parents had survived the Holocaust. And the idea of actually owning something that we couldn't be thrown out of was huge.
But maybe Charlie could be thrown out. In 2014, a state judge ruled the Casino Reinvestment Development Authority could seize Charlie's home, using the state's power of eminent domain.
And you have 45 days to vacate and that it would be bulldozed as all the other buildings right next to me had been bulldozed.
Does the public use provision of the Fifth Amendment have any meaning whatsoever? And the Supreme Court's answer by a 5-4 vote was effectively no.
The Constitution provides that private property may be taken for a public use with just compensation paid. But the Supreme Court rewrote public use to read public purpose, which is much broader.
And the thing that was crazy in the Birnbaum case is they weren't even sure exactly what they were going to use it for or when they were going to use it.
They said, we don't have to give you an answer. I'm thinking, where do we live? Is this Russia? Is this North Korea?
It's just a naked abuse of government power.
So Charlie went to court. 2 years later, the judge deemed the state's effort to oust Charlie a manifest abuse of the eminent domain power. New Jersey appealed, but in the end, Charlie prevailed. In the infamous case of Kelo versus New London, Suzette Kelo wasn't so lucky. The Supreme Court said, we can't decide what a public purpose is. We'll let the city councils decide that. That's good enough for us. Funny, but I had thought the justices were supposed to make constitutional decisions.
So the battle goes on.
So, Trish, in Kelo's case, Suzette Kelo didn't want to have her house taken away from her, as her neighbors' houses had been, to create a space for a pharmaceutical company to build a complex for offices and laboratories in New London, Connecticut. The New London City Council had voted to take all these properties and clear a space for Pfizer to build its campus because that would yield higher taxes for the city, property taxes. So the question became whether that was a legitimate public use. And the Supreme Court said, well, long ago we embraced this broader, more natural interpretation of public use as a public purpose. Now, what they were referring to was in the 1890s, they started to wonder in some cases, well, is a railroad a public use because people use the railroad? The public uses the railroad. Is a hotel a public use because people use that? We better make sure that we clarify that it's not. Those things have a public purpose, but they are, and you cannot have a taking in order to establish something, to a hotel or a theater on the ground that the public will use it. Here they turned that around in 2005 and use it to justify broadening the concept of what is a public purpose for which property can be taken. Now, this was such a...
But I can argue back with you, Judge, that public use, when it was written into the Constitution in 1787, nobody had in mind any of the public uses, even that you would agree exist today, that didn't exist in those times, like a railroad or any of the things that might fall within what they thought a public use encompassed. It just didn't exist yet, right?
Well, that's right. But their point here was in the 1890s to say we don't want a hotel to be deemed a public use for which people can be displaced from their homes. We don't want that. We want to adhere to some more compact meaning, less capacious meaning. And they turned that around in Kelo's case. But the key here is if a public purpose is not limited to a public building thing or a governmental building, and it can extend to things that will bring in more property tax revenue, that is so substantial an amendment of the Constitution, so substantial, it was not put to the voters. 46 states said, we ain't gonna do it. Many of them by statute, some by court decision, said our Constitution, our state Constitution does not allow that. This is so destabilizing to people's property values that we want you to know we're not gonna do that. Florida went the furthest, I think, where if a municipality requires some property, They cannot sell it for 10 years. And if they want, so they better be using it. And if themselves, not for a pharmaceutical company. And if they want an exception, they would have to get permission from 2/3 of both chambers of the state legislature and the governor's signature. So that's how significant an amendment this was to the Constitution. It still leaves the federal government authorized to do this, and the 4 states that have not repudiated it. So yeah, it was an enormous change, whether you think it was a needed change or not, or what wise change or not. It was a huge change, and it wasn't put through the amendment process. So here's what we have. Nor shall private property be taken for a public purpose, such as economic development that will raise more tax revenue. Not very comforting. So there is a very important distinction here between what a court can do to the Constitution and what the amendment process is for. And it was put there for a reason. We've used it only sparingly.
But the amendment process, of course, is also extremely difficult, as we've proven, because we haven't had that many amendments. Plenty of women who care about, for example, the Equal Rights Amendment might point to how hard it's been to even get equal rights for women enshrined in our Constitution, which we still haven't. So it was designed to be hard to amend the Constitution, right?
Yes. Absolutely. So we've done it 27 times, but the first 10 came all at once in 1789 and 17 times since then. Basically, what it amounts to is about once a generation, there's something so important that the people want to amend the Constitution, and that's as it should be. And as for the Equal Rights Amendment, which may, the 38th state just ratified it, Virginia, my home state of Virginia, or until recently home state. But whether that counts or not is not clear. And
remains to be seen.
Well, actually, what happened is that the Congress said ratification had to occur within a certain number of years, and it did not get the needed 38 states in that period. Then the later Congress extended it, but meanwhile, some states had rescinded their ratification, and then with the extension, new states ratified. And Justice Ginsburg commented on this just a few months ago. She said, I don't see how we can count the new states ratifying it without counting the old states that withdrew, which would mean there would be fewer than 38 and it would not be ratified. But I think the reason that it didn't get ratified readily was that the Supreme Court, through some decisions, took much of the teeth out of it by saying, hey, the statutes we have on the books pretty much provide just about what you get from the Equal Rights Amendment. They didn't say it in those words, of course, but they did make some decisions that made it quite clear that, as did the Congress, by the way, that discrimination against women was going to be extremely difficult to justify. We have the next slide, or is that it? Okay, so the show is A More or Less Perfect Union, and it is available. It's being shown on PBS stations around the country, even now, if you see it in your local listings, but it is streaming. You can see it free of charge from PBS Passport, if you're a member, or from freetochoosenetwork.org/Constitution, as you see on the screen. And it's on Amazon. They don't make it free, but it is available from Amazon. Or you can buy DVDs. And there is a companion volume called Voices of Our Republic. And I'm very proud to say that Sandra Day O'Connor and Ruth Ginsburg are among the 75 or 80 contributors to that volume with their thoughts on the Constitution, as are Ron Chernow, the historian who wrote Hamilton, Alan Dershowitz from Harvard, Mr. Sulzberger, the publisher of the New York Times, and some people who might surprise you, like Gene Simmons from the rock group. So, because the point of it is that the Constitution is so central to our self-conception, our way of life, and our government, that even though many people almost everybody seems to have an opinion, very few people have read it, the people in the book have read it and have a thought to contribute about it. It's a lovely book, really, a sort of coffee table book.
Well,
but that's really
great,
important.
but even,
because,
talking about the Constitution this year, we have to talk about the fact that it's the 100th anniversary of the ratification of the 19th Amendment, which is what gave women the right to vote. And we literally just celebrated last month that centennial. And that took a long time to amend too, didn't it? To get women the right to vote.
Well, it was actually what happened was that, well, yes, in the sense that the movement began in 1870. The ratification occurred, the amendment was ratified in 1920. But in 1914, when and beyond, as we were approaching the First World War and as we got into it, the women's movement sort of made a deal with President Wilson, who had opposed the amendment. We'll shut up and contribute to the war effort, and you pass the amendment after the war. And that's what happened.
Right. Well, we got there. We got there eventually, but
yeah, exact same thing happened in the UK. Same time, exactly.
Right. Yeah. Right. So as we talk about the Constitution, and of course, in the moment that we're in right now in our country, there's a lot of discussion about the United States Supreme Court. You sit on one of the courts that is just below the United States Supreme Court. Could you talk a little bit about the sorts of cases that have come before you in the years that you've sat on the DC Circuit Court of Appeals, and whether that's different from the United States Supreme Court?
Well, it's different from the United States Supreme Court and from the other courts of appeals. You all in Arizona are in the Ninth Circuit Court of Appeals, which runs from Arizona through California, Oregon, Washington, Idaho, Montana, Nevada. And that 30% of the cases that go to the Supreme Court come from that Court of Appeals. And by the way, 30% of the US population lives in that circuit. The DC Circuit has a jurisdiction of only 67 square miles and about 600,000 people. But we're in the seat of government. So there's very little commerce here. There are very few people. We get very few cases that involve real people or any commerce. It's almost all litigation with the government. 90% of it is. A small amount is criminal cases that could arise anywhere, same kind of case. But it's a third of our cases over the years that require about 75% of our time are cases challenging government regulations. So a new regulation comes out, some party that's adversely affected or that thinks the regulation isn't stringent enough will challenge it in our court. So the parties are public interest groups, environmental groups, trade unions, trade associations, individual companies, labor unions, very rarely a real person. And the issues largely have to do with the authority of the agency that put out the regulation. And as comes out in the TV show, in a more or less perfect union, the agencies of the government, federal government, issue about 28 regulations with the force of law for every law that is passed by the Congress. We live in a world in which our laws are not made by our legislators. They're made by people to whom they have delegated it. And we don't know who they are, and we can't vote them out of office. That is not the way this was set up by the framers. That's pretty clear, but that's where we are. And my court is sort of the adult supervision for that administrative state.
What do you say to those who view this debate over originalism versus a living, breathing constitution as simply a result-oriented argument between people who want a more progressive or liberal result and people who want a more conservative, smaller government, traditional conservative, social conservative result?
You know, I think that's really cynical. The case for the adhering to the written Constitution is a process one and a democratic one. The people were given a voice in the amendment process that they don't have in the administrative state. And, you know, the government, Congress authorizes large regulations, environmental regulations, and so on, because the public wants them. But the problem that we have is in the way they do it is that the Congress doesn't take responsibility for the actual regulations that burden people. It's very nice to say, let's vote for clean air, let's vote for clean water. But those things require trade-offs. And when the EPA puts out a regulation implementing the statute, they have to make policy decisions that the Congress didn't make and impose burdens on individuals or industries or neighborhoods or what have you. And there's no congressman to write to and complain about this. So if it were done properly by the Congress authorizing these regulations, passing them as laws, you would have a much more democratic outcome. Both the process and the outcome would be one in which the people participate. That's what we were given.
And so is that your prescription for how to avoid politicizing our federal court system? I mean, as we said earlier, we ask our federal courts so frequently to make decisions around things that we as a nation disagree on. And those are often issues with political overtones. So if we followed your prescription, do you think we would depoliticize the courts?
Well, since the Supreme Court in particular has accepted or maybe embraced a role as a moral philosopher and deciding matters that are really not in the Constitution, if we were to, if they were to stop doing that and the people could move by amendment, maybe they would do so. But, you know, let's take the question of abortion or abortion, or later on we could do same-sex marriage. Mary Ann Glendon at Harvard wrote a wonderful book called Abortion and Divorce in Western Law. And it's a comparative study of 23 countries. 22 countries, this is a study, most of these changes occurred in the 70s and 80s under the influence of the first powerful women's movement. There had been some in the past, of course. And 22 of those countries passed legislation resolving the issue. And 22 of those countries live in peace with that issue. Our court resolved the issue. And in court, someone wins and someone loses. In the legislature, there's always compromise. That's the difference. We live with
an interesting perspective. And you're right, of course, because you can only come up with an answer as a judge to a particular case that is between litigant A and litigant B that comes before you. You can't just decide on Saturday morning that you're going to write an opinion about something that you think would be a really good idea for the law to say, right?
Right. And if I may allude to Ruth Ginsburg again, she gave a speech at NYU on this very topic. This is about 2012, I think. Anyway, she observed that the court took the case with the most extreme law, that was the Texas law in Roe versus Wade, and struck it down with a broad stroke such that every law in every state on that subject was unconstitutional, and every state had to start over. And she said if they had handled it in a more case-by-case fashion, as the court usually does with any subject, it would have been much less contentious and more stable as an outcome. And of course, my point is if they had left it to the legislatures, it would have been totally stable and less contentious. You know, we all have implicitly agreed to live by the laws that our states and the federal government pass because we're represented there. That's not true when the court intrudes itself into a subject like this.
Well, of course, the folks who live in the District of Columbia might argue about whether they are as represented as they think they ought to be in the federal government that makes those decisions. But well, that's a different argument for another day, right?
That may be before my court and the Supreme Court in the coming year, because if Vice President Biden is elected president, and if the Democrats control both the House and the Senate, obviously they will control the House. One of the things they propose to do is to give the District of Columbia statehood. And that will be a nice question because the Constitution says there will be a capital district. And it also provides there are states.
Right.
And whether the distinction can be blurred without a constitutional amendment is a difficult question that's going to have to be sorted out.
Well, and I'm mindful, Your Honor, that you're not obviously going to give us opinions with respect to any issues that might come before you as a judge. And I'm saying that out loud because some of the questions that our viewers have submitted, I'm going to choose not to ask because you would smile politely and tell me that's an issue that's likely to come before my court and I can't answer it. But so let's switch gears a little bit and let's take a minute to remember that tomorrow is the 39th anniversary of Justice O'Connor's swearing in as the first woman justice on the United States Supreme Court. I went to law school on my very first day of law school, there having never been a woman on the US Supreme Court. And I literally, for me, that's a do you remember where you were moment when I watched her being sworn in, because for women and for women lawyers in particular, that changed our universe about what was possible and what could even happen.
But she'd done that before.
Yeah, well, I mean, can you reflect a little bit on what's happened in those 39 years?
Well, when she went to law school, she was a curiosity. There were so few women in the class, and it was impossible to get a good job at a law firm at that time.
She and Justice Ginsburg had that in common, right? Neither one of them could get hired as a lawyer when they graduated from law school.
I'm sorry, who? Justice Ginsburg and?
Justice Ginsburg couldn't get hired initially as a lawyer either when she graduated.
Yeah, that's what I'm saying, exactly. So she was, one of the few women at that time that was starting to change things. Law school enrollment now has a slight majority of women students around the country.
Are the courts different? The federal courts different in the 39 years since Justice O'Connor first went on the federal bench at the Supreme Court?
Well, they're certainly different in that respect, that there are many women now on the federal courts at all levels, not yet equal to the 50% or so in the schools or in the profession, but that's because people don't become judges right after law school. It's usually 25 years later, so there'll be more women coming. On my court, we have, I think, 4 women. I think that's right, out of 11 judges. Yeah, that's, but I don't, does it change the outcomes? I'm not sure. I can't point to a case yet where I think that's happened. But then again, as I said, my cases typically involve not real people, but institutions.
I love that. I do. I love that. So the title of this, around us kind of collectively searching for a more perfect union, or a more or less perfect union.
Yeah.
What is something besides voting? Because I hope everybody who is listening to us is going to make sure wherever you are on the political spectrum that you vote this November. But besides voting, what is something, Judge Ginsburg, that the ordinary American can do to help move us more toward a more perfect union?
Well, I think since we're voting for particular candidates, we ought to know, and people ought to ask or find out, what those candidates' views are on important matters like the reach of the federal government, the significance of a written constitution, what they expect from nominees to the Supreme Court. They are asking about that more, at least every so often. But I think an informed electorate would also react to some of the things that they see coming out of Washington in a different way and say, well, wait a minute, how is that possible? Write to the congressman and say, just how is that possible? Where is the authority for that? Or do you think maybe you should have asked your constituents about that, or maybe we should have had a vote or an amendment? There's all that. And then, of course, people getting involved in any way in political life. need to be informed about the system in which we live, the Constitution. By the way, the TV show, the More or Less Perfect Union, has a lot about the civil rights stories over the years because it is a Supreme Court created problem. In the 1850s, in the Dred Scott case, the court made up the idea that African Americans could never become citizens. It made up the idea that there was a constitutional right to own slaves. And in the 1890s, the same, well, different justices, Supreme Court 7-2, said equal protection, well, separate but equal is close enough. And we lived with that for more important, the African American public lived with that for 75 years, and we're still getting over it. That was a Supreme Court created problem because, as the court said in that case, rather than follow the written Constitution, they said they must be attentive to the mores and customs of the people. Well, the mores and customs of the people in several of the states was Jim Crow. That's a gift from the
very interesting.
There's nothing in the Constitution to justify that.
Well, an interesting perspective and an important way to draw this to a conclusion. I can't tell you, Judge Ginsburg, what fun this has been and how enlightening I know it's been for our listeners. We thank our audience and we thank all of our sponsors for being with us today. We hope you'll all join us for the next Constitution Series webcast, which will be on October 22nd, when our guest will be the acclaimed social psychologist from Stanford University, Dr. Claude Steele, author of Whistling Vivaldi, How Stereotypes Affect Us and What We Can Do. And for more information about that, you can visit o'connorinstitute.org. Thank you again, all of our audience, for being with us today for what was truly an interesting and provocative discussion.